welcome to Tech Law Talks. I am Anthony Diana, a member of Reed Smith's Tech and Data Group. In each episode of this podcast, we will discuss cutting-edge issues on technology, data, and the law. We will provide practical observations on a wide variety of technology and data topics to give you quick and actionable tips to address the issues you are dealing with every day.
Hello, everyone, and welcome to our first episode of our EU series of the Reed Smith Tech Law Talks. In today's episode, we will shed some light on EU data protection law and what kind of developments we saw in the past, as well as some strategies for when a data protection authority knocks on the door of your organization. This is Christian Leutner and Andy Splitgerber from the Reed Smith Tech and Data team in Germany. Christian, the General Data Protection Regulation, GDPR, is applicable since almost 3 years now. Looking back to the time when the GDPR was published and the developments over the past years, what do you think?
I think that one of the key drivers back then was the threat of significant fines for all entities that process personal data. 4% of the annual global turnover, or even 20 million euros, is a huge increase to the situation we had before.
Yes, this threat of extremely high fines opened the ears of management and board members in companies worldwide. Did the companies actually implement GDPR? Did we see a 4% fine so far?
Let's forward a bit. First, all players, entities, and authorities were keen to implement GDPR. Authorities reported that they were keen to find a practical approach to GDPR, but also told us that they were swamped with requests, that there was a lot of uncertainty in the market. One can say that many organizations in the EU and outside the EU worked heavily on implementing GDPR, and most of them have data protection compliance on their daily agenda. And then it really seemed that all fears came true. Google was fined 50 million euros by the French CNIL. The UK ICO published statements that it intends to fine British Airways up to 200 million euros, and Marriott was threatened a 100 million euro fine. In Germany, authorities published a framework to issue fines. And actually, this framework resulted in fines up to 14.5 million for Deutsche Wohnen, 9.5 million for 1&1 Telecoms, and 35 million for H&M.
Wow, yes. But did not many of these organizations object against the fines and have them reviewed by courts?
Yes, exactly. They objected with the procedural remedies in their respective countries, and one could say that almost all of them got a 90% discount. Marriott was fined with around 20 million euros. British Airways is now facing a 22 million fine. And 1&1 achieved victory in front of a court and is now facing only 900,000 euros as a fine. The court also raised concerns about the fines framework and was clear that the approach underlying the concept was wrong. It's also worth mentioning that all of these companies could show that they have made considerable efforts to comply with GDPR.
Okay, the fines are still pretty high compared to what was prior to GDPR, but the cases mentioned above clearly show that it is worth challenging them. We definitely see that authorities struggle with the situation and that they need to find a reasonable and adequate approach to interpret GDPR, also in a uniform manner across the EU. Same for the courts that decide on the objections against the fines. To me, it seems that many judges, mildly spoken, have a bit of a different interpretation of GDPR than the data protection supervisory authorities. This seems to have, at least for now, from a company perspective, a positive impact on the amount of the fines, but it also creates considerable uncertainty.
Yes, I agree. Now looking at this, what is your recommendation to companies that are facing a fine or another enforcement action by an authority?
I think companies should do the following 4 things. First, take the request from an authority serious. Second, ask for inspection of the records or the authority file. Third, cooperate with the authority, of course only to the extent necessary and reasonable. And fourth, critically assess and, if necessary, challenge the legal opinion of the authority, and any fine or other sanction imposed. It's also worthwhile taking a look into other areas like criminal proceedings or competition law. Enforcement actions by authorities under GDPR are pretty similar, and so why not using the advantage of experience in those areas?
Sounds good to me. But of course, without data protection compliance efforts, all these 4 steps will not help to avoid a fine if the authority knocks on the door.
This was today's episode of our Reed Smith Tech Law Talks podcast. We thank you for listening. Please send us your feedback and comments to techlawtalks@reedsmith.com. We hope to welcome you soon for our next episode. Have a nice day.
Tech Law Talks is a Reed Smith production. Our producer is Ali McCardle. For more information about Reed Smith's tech and data practice, please email techlawtalks@reedsmith.com. You can find our podcast on Spotify, Apple Podcasts, Google Podcasts, Stitcher, and reedsmith.com, and our social media accounts at Reed Smith LLP on LinkedIn, Facebook, and Twitter. This podcast is provided for educational purposes. It does not constitute legal advice and is not intended to establish an attorney-client relationship, nor is it intended to suggest or establish standards of care applicable to particular lawyers in any given situation. Prior results do not guarantee a similar outcome. All rights reserved.